Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In today's video, we are going to understand one of the most common yet often misunderstood terms used in the Indian judiciary, case disposed. You might have noticed this term while checking your case status on the court's website or on the eCourts portal. It often says, case status disposed. But what does it actually mean? Does it mean the case is permanently over? Or can it be reopened? Let's explore this step by step, including the related terms contested, dismissed, and rejected, so that every citizen can clearly understand what it means when a case is marked disposed by the court. Part 1. Meaning of case disposed. In legal language, disposed means that the case has been decided or concluded by the court. It indicates that a final order or judgment has been passed and the file is closed from the court's active list. However, it does not necessarily mean that the matter is over forever. Disposal only means that the court has taken a decision. It may be in favor of one party, against the other, or even on procedural grounds. A case may be disposed of on merits after full hearing of both sides, or without hearing due to withdrawal, default, or settlement. Thus, disposed simply means the current stage of proceedings is complete. But the dispute may still continue through appeal, review, or revision before a higher court. Part 2. Types of case disposal. The term disposed may appear under different categories such as contested, dismissed, rejected. Let's understand each one in detail. 1. Contested disposed. When a case is marked contested disposed, it means the matter was heard on merits after both parties presented their arguments, evidence, and submissions. The court has delivered a reasoned judgment. In short, the case was fought, argued, and finally decided. Examples: civil suit. Both plaintiff and defendant present their evidence. After full trial, the court delivers judgment. Contested disposed. Criminal case under Bharatiya Nyaya Sanhita, 2023. After examining witnesses and hearing arguments, the accused is either convicted or acquitted. This is also a contested disposed case. Practical meaning. The trial is concluded, but appeal, review, or revision may still be filed before a higher court. 2. Case dismissed. The term dismissed means that the court has decided not to proceed further with the matter. This can happen due to lack of merit, non-appearance of the petitioner, non-prosecution, procedural defect, violation of rules. In such cases, no judgment on merits is given. The case is closed without full hearing. Examples: if a civil plaintiff repeatedly fails to appear, the court may say, the suit is dismissed for default. It means the case is closed due to absence, not on merits. If an appeal is not pursued properly, the court may note, the appeal stands dismissed for non-prosecution. If a case is not maintainable under law, it may be dismissed at the preliminary stage. Summary: dismissed is equal to case closed without detailed hearing. Whether it can be refiled depends on the reason for dismissal. For example, dismissed for default can be restored by an application. Dismissed on merits cannot be reopened, only appeal or review is possible. 3. Case rejected. The term rejected is usually used for applications, plaints, or petitions, not for entire cases. When something is rejected, it means the document or claim fails to meet legal requirements or is not maintainable. Rejection generally happens before admission or trial, at the very beginning. Examples: if a plaint does not disclose a valid cause of action, it may be rejected under Order 7 Rule 11 of the Civil Procedure Code, CPC. If an application is time-barred, filed without jurisdiction, or missing mandatory documents, it can be rejected by the court or registrar. Illustration: A petition filed in a court lacking jurisdiction may be marked rejected, not maintainable before this court. Hence, rejection means the case or document was defective from the start and never entered the trial stage. Part 3 Updated Legal Provisions, 2023-24 Reforms. Key provisions governing dismissal, rejection, and disposal now fall under the updated procedural laws. Order 7 Rule 11, CPC 1908, still governs rejection of plaints, unchanged. Order 9 Rules 8 and 9, CPC deal with dismissal for default and restoration of suits. Section 272 of Bharatiya Nyaya Sanhita, 2023, BNSS, corresponds to Section 256 of old CRPC, 1973, and empowers the court to dismiss a criminal complaint when the complainant is absent. Article 136, Constitution of India continues to allow appeals to the Supreme Court after dismissal or rejection by lower courts. These updated provisions ensure that the terms disposed, dismissed, and rejected are used with distinct procedural meanings and consequences. Part 4 Can a disposed, dismissed, or rejected case be reopened? Yes, but only under specific legal provisions. If a case was dismissed for default, it can be restored by filing a restoration application under Order 9 CPC or BNSS Section 272 for criminal cases. If a case or application was rejected for technical reasons, a fresh filing may be allowed after rectifying the defect. If the case was disposed on merits, the only remedies available are appeal, review, or revision under relevant laws. Remember, disposed does not always mean closed forever. The type of disposal determines the next legal step. Part 5 Practical Example. A person files a civil suit for property possession. After full hearing and judgment, case contested, disposed. The plaintiff fails to attend hearings, case dismissed for default. The plaint is defective or lacks cause of action, case rejected under Order 7 Rule 11, CPC. Hence, the word disposed can represent different outcomes depending on the reason and context. Part 6 Key takeaways for every litigant. Always check the type of disposal mentioned: contested, dismissed, or rejected. Carefully read the final order or judgment before assuming your case is over. File for restoration, appeal, or review within the limitation period. Consult a qualified lawyer immediately when your case status shows disposed. Keep certified copies of all orders, they are essential for future legal steps. Conclusion. In conclusion, the term case disposed simply means that the case has been concluded at its current stage, but not necessarily that it is permanently closed. The nature of disposal, whether contested, dismissed, or rejected, determines what legal remedies remain open. Understanding these differences helps every litigant know their true case status and available legal options. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.